Hi, my name's Clare Murray, and I'm managing partner of specialist employment and partnership law firm CM Murray. And today we are talking all things professional discipline. And I'm absolutely delighted to be joined today by my partner, Andrew Pavlovic, who is a specialist professional discipline and regulation lawyer. So there's a lot going on in the world of professional discipline, particularly within the legal sector. What are the things that we're going to talk about in the next sort of 10 minutes or so?
So I'm going to talk about three things. First of those is personal misconduct and the SRA's approach to that. The second is dishonesty and junior solicitors, and whether the SRA's approach in relation to those cases is starting to change. And the third is cyber security, cyber attacks on law firms, and what firms can do to protect themselves against those attacks.
I know there've been a number of high-profile cases before the SDT and that the SRA has been looking into to do with personal misconduct of lawyers. How has the SRA's approach to personal misconduct changed over the years?
The SRA has always had the ability and has prosecuted cases involving personal misconduct. That's mostly been where a solicitor has been convicted of a crime. So obviously, if there is a crime involving dishonesty, then they're likely to be struck off. If it's a crime relating to an assault or something that doesn't involve dishonesty, such as perhaps a drink driving conviction, then the SRA would also regulate that on the basis that engaging in those sort of activities either lacks integrity or it diminishes the trust and confidence that the public has in the legal profession.
And so how has the approach of the SRA changed over recent years in terms of sexual harassment in the workplace?
Yes, well, as a result of the Me Too movement predominantly, there's been a lot more interest in this area. And the SRA has been looking at cases and has prosecuted a number of them. In the Beckwith case, at the end of 2020, the High Court quashed a decision of the tribunal and said to the SRA that it needed to be less dogmatic and it had to look at these cases and only prosecute cases where there was a nexus or a connection between the allegation and how that might actually impact on the solicitor, on his practice, and on the legal profession more generally. What that means is you have to look at the underlying SRA Code of Conduct, or in that case, the SRA Handbook, and there has to be a relevant rule that has been infringed.
And that was quite controversial. I remember when it came out, there were a lot of regulatory and professional discipline lawyers who were saying, this is built on a whole body of case law and you can't just look at the individual rules themselves because they sit on this platform of underlying law.
Yes, it is a controversial decision, and I think it does make it unduly difficult for the SRA to prosecute matters relating to personal misconduct. This requirement to have to find an underlying rule or section of the handbook to sort of underpin an allegation does make it difficult. And the particular allegation that was made in the Beckwith case was that Mr. Beckwith had abused his position of authority. The tribunal found that wasn't proved on the facts, but they then went on to say his conduct was inappropriate and he was found to have breached the relevant principles on that basis. The High Court said that wasn't correct. If there hadn't been an abuse of authority, he hadn't been found to have taken advantage of someone, there was no basis for the findings that he had acted without integrity or in a way which diminished the trust that the public had in the profession.
And so how has that then developed further in more recent cases?
So there was a recent case before Christmas. It involved a trainee named Mr. Fouracre. He sent a Christmas card to a fellow trainee containing quite suggestive and inappropriate comments.
The stuff of gross misconduct in an employment context, definitely, and sexual harassment type claims as well. Yeah.
The SRA investigated that and an adjudicator decided to give him a rebuke and ordered him to pay the SRA's costs. And the SRA adjudicator dealt quite summarily with the Beckwith case because they said he was at work when he sent this Christmas card. it was conduct that took place in the office environment,
Mm.
and therefore you didn't have to consider Beckwith, which was all about conduct outside of the workplace. Mr. Fouracre appealed the decision to the tribunal, arguing, among other things, that the adjudicator had not properly applied Beckwith, and the tribunal agreed, and they quashed the rebuke.
Wow.
And what they said was that the adjudicator had taken too much of a formulaic approach in deciding that Beckwith didn't apply simply because the conduct had taken place in a work environment. And what you had to look at was, did the conduct realistically touch on the legal profession and the ability to practice? Whilst the conduct which the tribunal itself described as disgraceful was undoubtedly very poor, there was no offence committed in terms of a criminal offence. This is where I think the SRA is going to have difficulties going forwards. Conduct which I think most people in society would recognise as being inappropriate and unwelcome. But where does it cross the line into becoming a regulatory issue?
I suppose it's the difference between, is it bad enough to lose your job, or is it bad enough to actually lose your entire career? Because that can be the consequence of, obviously, of the regulatory intervention. In terms of other types of behaviour, so I know there have been some cases around junior solicitors acting dishonestly. So what's the most recent approach of the SRA on those type of issues?
Yes, over the last few years, there have been a number of cases of junior solicitors acting dishonestly, and they tend to all have a fairly similar flavour, which is junior solicitor often complaining that they have too much work on, or that they don't have a supportive working environment, makes a mistake, which wouldn't necessarily or shouldn't be career-ending, but then they take steps to conceal that mistake. Or try and cover up the mistake, and in doing so they act dishonestly.
It's that stuff that they teach you on kind of in your first week of being a trainee solicitor, is whenever you make a mistake, just confess immediately, because there's very little that can't be addressed in one way or another.
Exactly, yeah, and a lot of these things, as I say, shouldn't be career-ending, but unfortunately, if you've acted dishonestly, the court's position is that unless there are some exceptional circumstances, the automatic rule is a strike off the roll. Exceptional circumstances might be, for example, if you had a medical condition at the time.
Right.
So there was a recent case of Clare Murray. She lost a briefcase containing confidential client information, and then she concealed the event, wasn't entirely truthful in her reporting of the event, and she was struck off the roll. She had mentioned during the proceedings that she had a medical condition, but she hadn't produced any medical evidence substantiating that. And the tribunal therefore said, well, we don't have anything to go on really with this medical condition. We can't find there any exceptional circumstances, and she was struck off. She appealed the case, and she was assisted on a pro bono basis in that appeal. She produced medical evidence, and the SRA, without a hearing, agreed to compromise the appeal and remit the case back to the tribunal. That may signify a change in emphasis and a change in approach, perhaps a recognition on the pressures facing junior solicitors, and also perhaps putting more emphasis on cultural issues in law firms where people don't feel that they can admit to mistakes or that they're overworked, etc.
And then finally, kind of boring but so important, cybersecurity. I mean, it's just one of the biggest and most expensive reputation and relationship shredding issues for law firms. What's the current position, regulatory position, in terms of cybersecurity?
Yes, obviously, as you say, hugely important issue. Particular issues that have come to the fore in 2021 have been ransomware attacks, where systems are infiltrated and firms are threatened that unless they pay this ransom, confidential client information is going to be released. And obviously that is a huge issue for law firms because they hold confidential client information, so there'd be issues with the Information Commissioner and the SRA to deal with, And as you say, there would also be the huge reputational impact. So there were 2 barristers' chambers that were hit with ransomware attacks in the summer of last year. More recently, there was a law firm, or a group of law firms, a group of conveyancing firms that were hit by a cyber attack. They had to shut down all of their systems for a period of time, and that has resulted in delayed completions and lots of complaints by clients. The issue was even raised in the House of Commons. So it does just go to show that, the sort of crippling impact these things can have.
So what sort of briefly, what kind of steps can firms take to protect themselves?
Obviously, if something like this happens, the SRA will want to know that it hasn't happened as a result of a systemic error or a lack of training. So being able to demonstrate that staff have been properly trained and know what to do is important. Obviously, the IT infrastructure element is important. So making sure that the systems are as robust as possible. And then if it does happen, obviously self-reporting is very important, both to the SRA and potentially if there's been a loss of personal information to the Information Commissioner. And there are very tight time limits involved in reports to the Information Commissioner that firms need to be aware of as well.
Okay, thanks. Sobering stuff.
Sorry about that.
We hope you've enjoyed this overview of some important professional discipline and regulatory issues for the year ahead, as well as looking back for the last 12 months or so. If you have any questions, if you have any concerns around professional discipline or regulation, please do get in touch. I know Andrew would be absolutely delighted to speak with you, and we'd be very pleased to support you. And in the meantime, thanks so much for listening. If you've enjoyed this, then please do like and share, as they say, and hopefully see you very soon. Thanks a lot. Take care. Bye.